tener la presencia de un experto en temas jurídicos, en términos también de comercio internacional. El profesor me pidió que no hiciera muy extenso su amplio currículum. Nos acompaña de la Shanghái Tong Law School el doctor Shen Wei. Él seguramente, pues, ahorita con la presentación nos va a dar mucha luz acerca de temas novedosos. Él va a tratar temas específicamente de Perú. Entonces, en ese sentido, lo que yo le explicamos, nuestra mecánica va a ser 45 minutos, después vamos a hacer una ronda de preguntas y respuestas. Y en ese sentido, posterior a la conferencia, vamos a hacer un pequeñísimo taller en donde aquellos que se quieran incorporar a hacer preguntas más en corto, pues están invitados. Entonces, la idea sería juntar estos dos eventos para que justamente pues, pudiéramos ahorita estar en ese sentido ampliando más el tema. Entonces, sin más preámbulo, profesor, welcome.
Good morning. Thank you for coming. Thank you for the introduction, which I don't understand. I hope we didn't say too many things about too many bad things about me. But before I start, I'd like to briefly introduce my institution as well as the topic. Some of you probably have been to China, so you know Shanghai University pretty well. This is one of our top 4 or 5 universities in China, and it's also probably the second oldest university in China in the modern educational sense. Our law school is relatively young. Just a couple of years ago, we celebrated our 10th anniversary. So our law school was doing pretty well in terms of official ranking. We are one of the top 10 law schools in China. This means a lot to us because in China in total we have more than 600 law schools. So top 10 means a lot. We are also one of the few mainland China law schools which are included in the QS ranking top 100 law schools worldwide. In China, usually, some of you probably know this, civil law schools are not well recognized in the QS ranking. So we are, in that sense, we are also doing pretty well. Now, the title, the topic for today probably somehow misleading. Some of you may think, I come to the wrong place to talk about something, to talk about a wrong topic. This actually is a topic given by the director of the Chinese studies, Centro. I think the case of Peru means there's a sort of relevance to Mexico as well as to China in the BIT context. I will talk about the first ever Chinese BIT case involving Chinese BIT. That BIT happened to be the BIT between China and Peru. So that's the importance of this case. So this is a long list. I'm not going to finish all of them because of the limitation on the time. In total, in this topic, I have more than 90 pages, 90 slides. So I'm not going to cover all of them in one of the topics. I try my best to cover some of them. So I will talk about FDI trends and risks globally. I will talk about BIT and BIT practice. My assumption is most of our audience today probably know this pretty well, so I'm not going to go deeper on this. Then I move to China's BIT practice as a ground or as a foundation for further discussion. Then I move to the Davidson versus Peru case, in which China Peru BIT was involved, in which this China Peru BIT actually was the governing BIT for this case. Then I will move to China's new move or some developments in BIT law and practice. So first, let's talk about trends and risks in FDI activities globally. I give you some figures so that you can easily understand what happens globally in terms of FDI activities. Globally, because of financial crisis in 2008, 2007 and 8. There's a huge drop of FDI in terms of volume. So the peak was 2007, then FDI, the value of volume of FDI dropped substantially in 2008, then 2009, then 2010. And it's probably very unlikely to see a full recovery in the past in the next several years. I think we can probably adjust the screen a bit because we're not able to see the bottom. Right? Oh, okay, sorry. Okay. So if you can see this, see here in 2014, 2015, still the volume or value of FDI would be lower than the peak time in 2007. And there's a huge change in FDI globally. The change was now the FDI outbound investment contributed by developing and transitional economies will be more than the FDI contributed by developed countries. So this will be a substantial difference before and after the financial crisis. So here we have some figures by region, and this will be very interesting to tell you. The U.S. is still the number one wholesale economy in terms of attracting foreign direct investment. China is the second one. So if you combine China and Hong Kong, probably the total amount will be more than the U.S. Okay. Now this will be very interesting because historically we will think U.S., Japan, and other developed countries are very important because they contribute the most FDI. But as a matter of fact, in the financial crisis, China catch up quite a lot. In terms of its FDI outbound investment, China ranked the third one in 2012, right after the U.S. and Japan. But again, if you combine China and Hong Kong together, the total amount was more than Japan. So ranking will be the second, right after the U.S. Now this is to show some major transitional or developing countries like Brazil, China, India, Mexico, South Korea. You can see they all contribute substantially in terms of outbound investment in the past several years in the financial crisis period. Now, if we talk about inbound investment, right, if you are talking about how to help clients investing into some countries, then the concern will be political risk, economic crisis, policy change. But if you talk about attracting foreign investment into your own country, then the concern will be who is the major investor. Then who will be the major investor? Then their policy change, their policy landscape will be more important. So this shows you how the policies changed in the past several years in the financial crisis when different countries attract foreign investment. So we see a drop of liberalization or promotion policy. But in the same time, we see a rise of restrictions and regulations in the FDI sector. It makes sense if you look at the financial crisis because most countries will be tightening up their regulatory base in terms of attracting foreign investment. But it also makes sense if you think about the fact that more developing countries and emerging countries actually are contributing more investment into other countries. Then you understand why we are not talking about liberalization and promotion. Instead, we're talking about restriction and regulation. Okay. So GIT and the GIT practice. Now, basically, there's a huge network of investment treaties or investment protection agreements So we have a various types of investment agreements or treaties. We have VIPs. Globally, we have more than 26,000 VIPs. We have probably 2 dozens of free trade agreements worldwide. Some countries like to sign economic partnership agreements instead of VIPs and free trade agreements. In particular, Japan. Japan is that type of country which likes to sign some version of VIP or free trade agreement. And regional integration agreements are not that many. Only probably in North America we have NAFTA, and in some regimes, for example, ASEAN, we have an ASEAN investment agreement. But overall, we don't have many regional investment agreements. We don't have many multilateral agreements, except treaties on gas, dealing with a very specific topic in the investment activities. Now, this is a chart showing you the trends in investment treaty agreements. Overall, after 1984, there's a growth of investment agreements. Now, this shows you economic cooperation agreements with investment provisions. Globally, we have probably 300. Now, the purpose of BIP or bilateral investment treaty is to protect foreign investment and foreign investors. The reason is if there's any dispute between a foreign investor and a host state, then under the conventional public international law, the foreign investor needs to exhaust local remedies, which means that the foreign investor can protect its rights based on local court system, litigation system. But then, in order to promote foreign investment, in order to protect foreign investors, the idea is we need to have a separate regime so that they can bring the dispute to the international institution or international court. Then the exhaustion of local remedies can be avoided. That's the whole idea of having this BIP regime. So in BIP arbitration or BIP regime, we always have 3 parties. We have a host state and a home state. For example, Chinese investor comes to Mexico, then the Mexico government decision, they can bring Mexico government to ISID or to Washington Center for arbitration. So investor is always a foreign investor, host state is always the country which hosts foreign investment. Home state is like China, which treaty support. Now, globally now we have 26,000 VIPs. This is a trend. There's a huge growth after in the new century. And this is a very interesting chart. This is so-called top 10 signatories of VIPs up to 2010. You can see Germany is a top 1 country. Germany signed 136 VIPs. China is the second one. China signed 129 VIPs. Then you see more other countries. Now, based on this, you can draw a couple of conclusions. One conclusion is most VIPs probably were initiated by the developing countries, not developing countries. Why is that? Because they want to create VIP regimes so that their investors can protect their rights and their properties in developing countries when they move to developing countries. So that's the reason. Then the second conclusion you can have is some developing countries prefer to have VIPs. For example, China, Egypt, and probably South Korea. Why are these developing countries also active in signing VIPs? The reason is to give a strong signal to foreign investment community. They are respecting their respecting foreign investment. That's why using VIP is involving different countries. Now, this is another interesting chart, so-called the top 10 respondents in investment arbitration. Unfortunately, Argentina is the top 1 country which is frequently sued by foreign investors because it's a financial crisis in 2003-2002. Then you have Mexico. Unfortunately, Mexico is the second frequently sued country in PIT arbitration. But the main reason is not because of financial crisis, because of NAFTA. Canadian and American investors frequently rely on NAFTA for rights protection, for investment protection. And NAFTA has a section or chapter on investment protection. Then Canadian and American investors can bring Mexican government to Washington Center for arbitration. And very interestingly, in this chart, you don't see China. Okay. Why is that very puzzling or interesting? Because on the one hand, China signed more than 120 BITs, right? So theoretically, any foreign investor who's not happy with the Chinese government can easily bring the Chinese government to Washington Center for arbitration, right? So that's something you can easily anticipate. On the other hand, you always heard about bad news coverage about Chinese government in terms of rights protection, investment protection, and for human rights violations, and so on and so forth. Then your assumption is Chinese government is very likely to be sued by foreign investors, right? Whenever they are unhappy with the Chinese government, they can bring the case to the Washington Center. And on the other hand, we have such a large number of VIPs. But this didn't happen. So that will be very puzzling to you, right? Why this didn't happen in the past 2 or 3 decades. So I will come back to this point. Okay. US, Canada are also very interesting countries to study in this chart. Why they are always, or they are often targeted by foreign investors. Now, the logic is that they should not be sued or brought by the foreign investors that frequently, because they are able to provide a rule of law, right? Court system for rights protection, for compensation, so on and so forth. Then the question is why Canada, the US, these countries usually have very strong rule of law or infrastructure for rights protection. Why foreign investors still have strong preference to sue them? So the answer is that these countries are relatively rich, so they are able to provide more compensation. That's why foreign investors are more willing to arbitrate their disputes with the US and Canadian governments. Now this is the respondent states by region. Again, we have to take Argentina away from a region and put it as a separate category because it involves more than 2,000 or VIT cases already. So it's a major target for VIT arbitration. Then you can see Eastern and Central European countries are often targeted for VIT arbitration. But if you look at the Asia countries, right, they are not involved in VIT cases that often. Okay. So this is to show globally we see a large number of VIT cases, but at the same time we don't see many Asian countries involved in the VIT arbitration. Okay. So why is that? That will be another interesting question for research, right? Why Asian countries are not involved in VIT arbitration cases that often, but at the same time they signed a large number of VITs. So then, to recap, so far we have close to 250 PCD cases involving various countries, and we have 100 cases under principal arbitration rules. we have probably 20 cases with the so-called Chamber of Commerce. So-called is a very neutral, impartial venue for BIT arbitration. And we have various cases with ICC, ad hoc, so on and so forth. Okay. So we skip this, then let's move to China. Okay. So we have several interesting questions to ask. The first one is China a very important BIT player in the world? Why is that? Because up to date, China signed 129 BITs, right? It's a number one country right after Germany. And China also is in the process of signing more and more free trade agreements. And this is actually something China and Mexico want to achieve in the near future. They want to sign a free trade agreement with Mexico as well. So China signed ASEAN investment agreement. China and signed other investment instruments with various countries and regional institutions. So the question is, why is China actively recruiting BITs? Why is that? What's the purpose? So based on what I said, there are probably two possibilities. One is if China is a developing country, then signing a BIT, signing more and more BITs is to attract foreign investors, right? So that can give foreign investors or foreign investment community more comfort for more investment into China, because China lacks a road or infrastructure, so on and so forth. So probably that can explain why China signed BITs and free trade agreements. But the question is, again, if that's the case, why we don't see many BIT cases involving China, right? So that will be a very interesting perspective to look at China. So far there's no single case brought by any foreign investor against China to issue. So why? And there are two sorts of arguments. One line of thought is offered by Chinese scholars, saying our rule of law is actually not that bad. Our legal system is functioning pretty well. That's why we don't see many BIT arbitration cases. Otherwise, foreign investors will already sue Chinese government for violation of rights protection and so on and so forth. Right? So this is offered by Chinese scholars. This seems a very problematic argument. If you look at other high-profile cases involving Chinese government with foreign investors in various disputes, especially the dispute with Google, because Chinese government, because of this internet censorship system, Google was completely moving away China to Hong Kong. This is a very high-profile dispute between Chinese government and Google, involving the U.S. government as well. So at that time, the then State Secretary Clinton condemned the Chinese government for the internet information censorship. So if you look at these high-profile cases involving Chinese government and foreign investors, you will think probably this line of argument is not well established. Then the other line of argument is offered by Western scholars, saying the reason for very few BIT cases involving Chinese government is really about Chinese BIT itself. Okay, so this is a more law-based argument. Why is that? Because Chinese BIT, I will talk about this later on, you basically can divide the Chinese BITs into several stages. Okay, so we say first generation BIT, second generation BIT. China probably has 4 generations BITs. So one generation, they are all different from each other. So I will talk about this later on. The first generation Chinese BIT has a very narrowly defined concept of dispute. So in Chinese old generation BITs, the definition of dispute is narrowly defined. How narrow? Usually you will see this kind of definition. The dispute in relation to the amount of compensation in the exploration can be brought to estate arbitration. What does that mean? That means the dispute over the exploration itself cannot be brought to Washington Center for arbitration, but only if the investor is not happy with the amount of compensation, then you can bring that dispute to the arbitration. So that probably can explain why China is not frequently involved in the BIT arbitration. Okay. So we will talk about this later on. The other thing is about China's status in FDI activities. So how to define China? What's the function or what's the role of China in global FDI activities? It's a major capital importing country or a major capital exporting country. So if it's a major capital importing country, then signing BIT will help China to attract more investment. If China is a capital exporting country, then the BIT, signing more BIT actually is to provide legal protection to Chinese investors when they go abroad. So the function of BIT can be completely different if China's function or Chinese companies' role in FDI activities is different. Okay. So this is a chart, okay, showing the growth of China's outbound investment starting from 1999. Okay. Historically, Chinese government was never actively encouraging Chinese companies to invest abroad. Okay. Because historically we are a very developing country. We want to attract more investment. We don't want to invest overseas. But there's a change, right? If you look at this chart, there's a change, especially after 2000. Right? There's a huge rise of outbound investment up to 2013. Right? So why did we witness this rise? Why do we see this change? Because in 1998 to 1999, the Chinese government put forward a so-called global policy, encouraging bigger Chinese companies, especially state-owned enterprises, to invest more overseas. Okay, so there's a policy change at that point. Then you see a gradual increase of outbound investment. Let me tell you something interesting. In the global Fortune 500 list, including 500 the most profitable or the largest global multinational companies, China actually is the second country, which has 72 global Fortune 500 enterprises, ranking right after the U.S. U.S. is the number one. Than China. So it's a very surprising figure if you look at this. Okay. You will think probably Chinese enterprises are not that important because most of them are state-owned enterprises. State-owned enterprises represent low efficiency, low profitability. But as a matter of fact, that's not true. Part of the story is that they are very big, especially in the global landscape. They are very important, very dominant in some sectors. For example, we have Big Four commercial lenders. They are in the top 20 commercial banks worldwide. We have Sinopec, which is the number one, number two oil company in the world, and ICBC, which is the major bank, commercial bank, whose capitalization actually is larger than Wells Fargo in the U.S. in terms of capitalization. So these players, these companies are very dominant in the global activities. Okay. Now we see some high-profile investment activities involving Chinese companies. Some were successful, others were not as successful. Largely because of Chinese government's go global policy, encouraging Chinese companies to invest overseas. Okay. Now let's move to a Chinese BIT. As I said, we can easily divide the Chinese BITs into several generations. So this will be the first generation, starting from 1982 to 1989. Now, the first generation started from 1998 because that's the year when China signed its first BIT with Sweden. That's the first BIT China signed. Okay, then I took the first 10 years for calculation. Okay, you can see 48% of BITs signed in these 10 years was signed actually by China and Western European countries. So Western European countries were the major counterpart countries for Chinese BITs in this first decade. The major reason for that is, for inbound investment, not for outbound investment. We move to the second decade, from 1990 to 1999. 40% of Chinese BIT was signed by China and Asian countries. So there's a switch from Western European countries to Asian countries. Okay. Then we move to the most recent decade. Between 2000 and 2010, you can see the majority of Chinese BIT signed in these 10 years were with the African countries. Okay. So it's a very clear switch or change or trend moving from Western European countries to Asian countries and to African countries. Why was that? Largely because there's a growth of outbound investment activities involving natural resources, oil, etc. And all these natural resources, oil, are in Africa, Asian countries. That's why Chinese government wanted to use BIT for rights protection so that Chinese companies can be well protected and invest in African and Asian countries. Okay. So now let's move to this list. This will be a very interesting list. Now this list has 3 cases. All these 3 cases were filed with this is Washington Center, based in Washington D.C. Okay. Now these 3 cases were the only cases involving Chinese BITs so far. Okay. Let me give you some background information. Now we will talk about this case relatively more detail later on. Okay. So this is the first case. In this case, Hong Kong-based investor sued Peru in Washington Center. Okay, so Peru was the respondent. The Chinese investor is on the claimant side. Okay, this case is interesting. This case is the first case a foreign investor sued Chinese government for land disputes. Okay. Because this is a Malaysia company invested in the real estate property in China, but because in China, under the Chinese law, there's a legal restriction. If the investor failed to put money into the project for 2 years, the government can take back the land. And this Malaysian investor, failed to put money into that project, then the Chinese government took back the land. That's a dispute. And this is the first ever case involving Chinese government as the respondent, not a claimant. But this is also a very interesting case. Why? Because this is also one of few cases in which the claimant, in the middle of the arbitration proceeding, dropped the case. So this Malaysian investor, in the middle of the arbitration proceeding, dropped the case, withdraw its claim. This was very unusual in Washington Center, in ICSI arbitration. Part of the story, we don't know exactly what happened behind the curtain, what was on the negotiation table between the Chinese government and this Malaysian investor. part of the story was the Chinese government successfully persuaded this Malaysian company to drop flight. This was very unusual again in Washington Center's history in the past 5 decades. This is another case involving China, but again, the Chinese company sued Belgium. Belgium is a developed country, right? Typical developed country. Now this case, Yunnan is one of two the largest insurance company in China. In the financial crisis, Ping An went to Belgium to acquire Fortress, which is a major insurance company in Belgium. But because of financial crisis, Belgium, the government, acquired equity in this Fortress company. That's why Ping An would not be able to proceed with this acquisition deal. So Ping An sued Belgium based on China and Belgium DIT. Again, if you look at this list, right, this case was dropped already. If you look at these two cases, so far the only two cases involving Chinese DIT, the Chinese entity is always on the claimant side. The Chinese government actually was not involved. The foreign countries' governments were involved on the responding side. So this is a very interesting angle to look at Chinese DIT. Okay. Now let's move to this case. Okay. Again, this is the first case. This case gave us a full manual of Chinese DIT because some of you know this. In DIT arbitration, usually there are 3 stages. Right? The first stage is you will have an award on jurisdiction. Then you will have an award on merits. Then if the respondent government was not happy with the award, the government actually can apply to the Washington Center for annulment. This case involved all these 3 stages. So recently, in the last a couple of weeks, the Washington Center issued the annulment award. So this case gave us a full manual of Chinese DIT. I'm not able to cover all perspectives of this case, but I only give you some interesting perspectives of this case. First, let's try to understand the significance of this case. Why is that so important? It's not because Peru was involved. It's really because it's the first ever case involving Chinese DIT. As I said in the beginning, China signed more than 129 DITs. On the other hand, Chinese government was rarely involved in the DIT arbitration. So this is a good case to show how these Chinese 129 Chinese DITs are interpreted, are applied by the DIT arbitration tribunals. So this is the significance. Now, let me give you some facts about this case. Okay, it involves a variety of important international law issues. Okay, first, that is a Hong Kong-based resident. Of course, he is a Chinese citizen, but Hong Kong is a special administrative regime, and Hong Kong itself can sign DIT with foreign countries. Hong Kong signed 12 DITs, but all of the counterpart countries with Hong Kong are Western European countries. Hong Kong never signed any DIT with any developing country. Okay, so theoretically there will be a very interesting international law issue. The issue is, can a Hong Kong resident rely on Chinese DIT for rights protection if Hong Kong itself actually signed DITs with various countries, but Hong Kong didn't sign any DIT with Peru. Okay, so this actually is a very important international law issue, heavily arbitrated in this case. So Zara invested in Peru and set up a TSD Peru SAC. You know more than myself. This is a limited liability company and Peru company law. But Zara invested in Peru through SPV, special purpose vehicle, in British Virgin Islands. So that's another very interesting international law issue. Can ZAR rely on China-Peru BIT if the investment actually is flowing from the British Virgin Islands rather than China? And then the Senate is the tax authority in Peru, froze TSG's bank accounts. Then ZAR claimed that this constitutes an exploration without compensation. So the whole legal issue involved in this case is about the exploration clause in China-Peru BIT. Okay. So for the first award on the jurisdiction, there are four important legal issues. Okay. The first issue is the scope of dispute. Okay. As I said, the first generation Chinese BIT's definition of dispute was very narrow. How narrow? Only the dispute over the amount of compensation involving the exploration can be brought to arbitration, right? So then the Peru government, the argument put forward by the Peru government was we can arbitrate in this case, but can only arbitrate the amount of compensation. We cannot arbitrate the exploration itself. Okay, that's the legal issue here. The second issue is interplay between domestic and ICSD arbitration. The respondent, the Peru government argument was you have to exhaust the domestic remedies. Then you can move to state arbitration. You cannot go to the Washington Center for arbitration without exhausting local remedies. In other words, ZAR can sue Peru in Washington Center only after ZAR himself exhausted all the local remedies in Peru. That's the second legal issue. The third legal issue is so-called consent to state arbitration. Now, this is a little bit complicated. In BIT arbitration, let's move from BIT arbitration to commercial arbitration. In commercial arbitration, you have to have an arbitration agreement or arbitration clause, right? Then the parties can arbitrate their disputes. In BIT arbitration, it's more complicated because the respondent is the host state, the government. So under the international law, the government cannot be sued in any court or any arbitration venue unless the government gives consent in advance. That's the idea of consent. So you have BIT. Let's say Peru and China have this BIT, but that doesn't mean the Chinese investor can sue the Peru government without having the consent from the Peru. So Peru needs to give the first consent, then you can move forward with arbitration. So the Peru government said we never give this consent. By signing the BIT doesn't mean we give you consent. And without consent, you cannot sue us. So that's the third legal issue. The last one is so-called most favored national treatment clause to procedural rights. Now this is a typical international trade law issue. In international trade law or in WTO law, you know this, right? If we don't have civil rights, right, in Mexico, then we can argue we still can have that rights if Mexico gives that rights to any third party countries. So this is so-called most favored national treatment. Now in BIT arbitration, there's a MFN clause to procedural rights, which means this is actually the argument made by the claimant, saying, well, you didn't give us consent, that's fine, you didn't give us the waiver of exhaustion of local remedies, that's also fine. But because Peru gave other South American countries procedural rights, for arbitration without having the consent in the first place, you need to give me that rights. That's the argument, so-called most favor national treatment to procedural rights. Okay. Now, this is the four major legal issues in the jurisdiction issue. Okay. We move forward. Okay, there are too many details here. So what's the substantive legal issue involved in this case? The substantive legal issue involved in this case is so-called exploration. Okay. So under the U.S. constitutional law, the concept is taking. So the government can take away private property. That's the idea. So in international law, the concept is exploration. Okay. I don't know what equivalent concept you have in your constitutional law, but the modern international law recognizes exploration, allows the government to explore property, private property, on the condition that exploration serves public interest, comply with the procedural rights, and give due and proper compensation. As long as these conditions are satisfied, the government can take away private property. So this is here, right? Unless the following conditions are met for the public interest under domestic legal procedures without discrimination against compensation. As long as these four conditions are satisfied, the government can take away, can explore assets or property. That's legal exploration. But as I said, in this case, this investor said the tax authorities freezing of its banking account constitutes indirect exploration. Okay. Now, BIT usually do not define exploration. Okay. As I said, that's the typical way of interpreting exploration in BIT, in Chinese BIT, in US BIT, in Canadian BIT. There's no huge difference. The way to define BIT actually is to list these four conditions instead of giving a definition. So the lack of a uniform definition is the greatest source of trouble in international law as well as in BIT arbitration. Now, in deciding this case, the tribunal look at two parts. One is the effect of the measures. The second one is the severity of the effects. To see whether there's a huge drop of the monetary value of the investment or of the assets. If yes, then that's indirect exploration. Then the government needs to compensate. Okay. So these are some the arguments made by the Peru government. For example, evidentiary requirement, right, for causation between a measure and subsequent damage. Impact is determined by the facts. The anti-jurisprudence, problem with the tribunal's approach in this case. So all these arguments are very technical, very law-based, and precedence-based arguments. Okay. So we skip this. Okay. So importance of this case, again, first China BIT case, critical issue yet tested. This is the first case involving Chinese BIT. This is also the first case to see how Chinese BIT standards or principles or elements are applied by the BIT arbitration tribunal. And so there's another interesting angle we probably can look at this case, so-called international law's influence on domestic law in practice. So again, back to my previous comments, China's BITs can easily divide into several generations, right? Now, so how to divide these generations? How to move along this evolution? The first generation started from 1982, right? this first China-Sweden BIT. Up to 1998, China signed a BIT with Barbados. So this is the first generation. Then why China-Barbados BIT was very important in 1998? Because that's the first BIT in which the definition of dispute was fundamentally widened up by the Chinese government. So dispute, the definition of dispute is not only about the amount of compensation, but also about the exploration itself. In other words, any type of dispute can be subject to arbitration. Okay? So this is the second generation. The third generation BIT started from 2006 when China signed the BIT with India. Why is that important, or why 2006 was the cut-off point? Because in that BIT, for the first time, Chinese government recognized the concept of indirect exploration. Previously, Chinese government never recognized that concept. Okay. Now, the fourth generation started from 2009 when China and Canada signed BIT. Why is that? Because this is the first BIT in which the Chinese government incorporated some unusual terms such as environmental protection, IP rights protection. So these are basically four generations of Chinese BITs. Now we are actually moving towards a new trend. This is what I like to talk about a bit in the end. So the new developments are really about what? Are really about its multilateral movements. So for the first time, Chinese government signed an investment agreement in 2009 with the ASEAN. This is a 10-country group or international regional organization. And for the first time, Chinese government signed a triangle three-party investment treaty with South Korea and Japan in 2012. Then you will have a simple question: why Chinese government moved that direction? Right? Previously, only signed BIT with a particular country, signed free trade agreement with a particular country. Why, at that point, by 2009, 2012, Chinese government was moving towards a multilateral direction? The reason is really about the reason is really about so-called, status quo of global investment legal framework. Unlike WTO, we have a bigger umbrella on top, right? Everything is under WTO regime, under WTO framework. But in investment regime, we don't have that umbrella. WTO doesn't work for rights protection, investment protection. Instead, we have this massive landscape. This massive landscape involving 2,600 BITs, 300 economic cooperation agreements, so on and so forth. So the trend is how to move towards a multilateral framework in which we can have a WTO similar type of framework for investment protection. That's why China is in that process of moving towards that direction. Especially if you look at the U.S. TTP negotiation, TTIP negotiation, the U.S. is trying to lead a multilateral investment treaty negotiation globally. So, but TTP doesn't involve China, excluded China. So Chinese government is very anxious to be part of it. That's why China started a couple of years ago to have this multilateral investment treaty negotiation. So this ends my presentation. Thank you very much.
Vamos a hacer una ronda de preguntas y respuestas. Quien quiera participar, les pedimos si se presentan para que el profesor los conozca y los conozca. ¿Alguien quiere participar?
My name is Lourdes Martinez. I'm professor at this university and another university for the Mexico City, the University of Autonomous of Mexico City. Well, my question is about the regulation, the global regulation of foreign investments. I think that it is better, I know that for developed countries, it is very interesting to have a divided, fragmented legal framework over the world. But in the case of developing countries, I think it is better to have a global investment legal framework for all the countries. Because sometimes in developing countries, we don't have the competences, legal competences to defend the problems put on the scene. So, well, what do you think about this? For example, in sustainable framework, there is a big lack here, for example, in Mexico, because of the practice of some multinational enterprises. They respect the ecological legal issues in their countries, but not in the countries that they invest. So, for example, there is a big problem with the waste, industrial waste. So to manage it is very costly. So, well, this is my point, and it is very interesting, your research. Thank you very much. It is really great. And I would like to ask you, what do you think about this from the point of view, not the China, the Mexico, or Latin American, Africa? Thank you.
Okay. So from the developing countries' perspective, the benefit of global investment protection regime certainly is good in terms of public goods provision, right? In terms of rights protection, in terms of rule of law promotion, so on and so forth. So all these are good perspectives. So the developing countries can enjoy benefit a lot. But the real concern of developing countries in the global investment treaty negotiation or multilateral investment treaty negotiation is the standard. What will be the proper standard for rights protection? If the standard is very high, then there will be a very high chance to be sued by the foreign investors, right, in the BIT arbitration regime. So that will be the major concern. So that's also the concern shared by the U.S. government, because there's a withdrawal of its previous liberal stance in the BIT or investment treaty negotiation by the U.S. government. Because a very high standard BIT protection, very high rights protection standard in BIT will lead to more chances of arbitration involving the host state. So the U.S. government's concern is if we are not able to raise the standard that much, otherwise it will be more frequently sued by foreign investors. I guess that will be the same concern shared by the developing countries. Yeah, so what will be the proper standard? That will be the major concern.
My question is, you showed us well, part of the modern history of FDI of China, firstly in Europe, then Asia, and Africa. Which one do you foresee will be the next for China? I mean, this moment we know when we see China, well, FDI is not just drawing a specific section. I think it's very more diversified. However, do you think there will be like a region like it showed before for China's FDI, or do you think it will go back maybe for Europe, or do you think now it's moving forward maybe to America, Latin America?
I don't see a consistent trend for Chinese enterprises investment overseas. My observation is they go wherever they can get natural resources, oil, minerals, etc. The other thing is that they basically two trends. One trend is they go to developing countries for raw materials. The other trend is they go developed countries for good target companies. So these are two trends I can observe. I can't predict what will happen in the next round of FDI.
Se presenta, por favor. José nos convoca.
Sí, Joaquín Vite, the Law Faculty, Integration Economic Law, here in UNAM. But I wonder, it's very remarkable to speak the talk is about. It's very deep. There is an issue in economic international law, which Mexico has got some cases, especially oil, Hannibal. It is a very, very interesting your opinion about this and this kind of agreements in what it calls sovereignty immunity. The sovereign immunity is very interesting. Of course, I want to hear you because there is a lot.
Yeah, I agree. This is a very interesting topic. This actually is a very large topic. Most countries probably will adopt the so-called restrictive immunity principle, but Chinese government made it 100% clear in the Congo case a couple of years ago. We only adopt or we only apply absolute immunity principle. So that's a full stop, no argument in the Congo
That's
case.
it.
The central government, through the National People's Congress, gave the opinion letter to the Hong Kong Supreme Court. That's the stance taken by the Chinese government. Absolute immunity principle.
Jaime Orzana, student of Master in Economics here in UNAM. The question is somewhere in an aspect. The enterprises are acquiring in different levels human rights in the world. In Mexico, the enterprises has human rights, and it is not defined the level of these rights. The question is in this area. Can or there is some evidence some enterprise has taken apart not the dispute not in the area of investment or global investment on the EIP. They have aparted from that to a human right of the enterprise and have taken to the Supreme Court in Jiao the case. I don't know. The concept could be in Mexico could be pro person or in favor of the person. Discrimination, for example, you can I don't know jump to the global investment and to say I am being discriminated like a person. The person is the enterprise in that case.
In BIT arbitration cases, human rights overall is not the major legal issue for arbitration. So in most cases, in BIT arbitration cases, the legal issues, substantive legal issues involve like exploration, compensation, fair and equitable treatment, so on and so forth. It's more about rights protection. So there's certainly there's argument in the scholarship as well as in the UED or European Union whether the investment treaty protection, the investment treaty should move that direction. There's argument or there's a counter argument as well. But overall, human rights is not the major legal issue involved in the BIT arbitration. So I'm not sure if I answered your question. Okay.
Good morning. My name is Betty Juarez. I'm a law student here and PhD law student. It's not so related about investment, but about Chinese legal system.
Okay.
Last October, in the fourth plenary session of the 18th Party Congress, the party agreed on supporting the socialist rule of law. So my question is, do you think China can continue to develop their own version of legal modernity, or do you think that eventually China will have to adjust its rule of law model to these Western demands of, for example, to give up on the principle of party leadership and to construct an independent judiciary?
My feeling, this is a very big topic. Actually, beyond my capability, I'm not constitutional law professor. My sense is it's not the intention of the Chinese government to move away its socialist rule of law system. So the whole point of this plan in late last year was to strengthen the socialist rule of law, to improve its systemic framework instead of moving away from its current status. That's my understanding.
Okay, so China will continue on.
Correct. That's my
their own way.
At least it's not a ruling party's intention to change that status quo.
I am Maria Teresa Gutierrez from the Economic Research Institute. I have a project about the same subject, not about China more general, but I would like to ask you something about this prospect of global investment legal framework. Finally, when you observe things one by one in each country, particularly in developing countries, you can see that in fact the more and more the countries try to have its own version of BIT. So I don't think that this kind of a proposal maybe could work for some countries in Asia. But for example, in my experience in Latin American governments, the more and more are reluctant to have this kind of proposal. First of all, because they know the more and more how much is cost, ICSID or institutional suit. If you see, for example, Ecuador government, Bolivia government, how much they are paying in this kind of suits. So that kind of tendency, in my opinion, is quite unpopular. But something more, when you see the discussion right now between, for example, Germany about this subject in its own European framework, you can see how much that proposal is unpopular. So I think the tendency will be to sign more VIPs, that is possible. But when you see, for example, the case of Argentina, it's quite interesting because you see that Argentina is making procedures, legal procedures about it. You talk about Canada. If I understood it, Canada has a deal with China. Okay, but I remember that Canada introduced many small and important laws before to sign with China. So only, maybe the Asian countries can sign a little bit blind, and I don't know. But in the case of Latin America, I insist that more and more the governments are taking into consideration many things, because finally when you see that the mining, for example, the Chinese investment in mining is the more and more important in Latin America, oil. So we are not ready to have a suit 3 months later that we signed a deal with China.
I agree with you. There's a group of scholars arguing against having a global investment deal framework. I totally agree with you. The argument put forward by them is there's no such need because the BIP's 2600 BIP's globally work are functioning well. Besides, in the economics terminology, there's a concept so-called network effect. Basically, all the major terms in these BIPs share the similarity. So there's no need for a global framework to unify all the terms. So I agree with you, there's such an argument, academic argument against global legal framework. But in practice or in reality, some major countries or international institutions like to move forward towards multilateral framework. In particular, the US, EU, China, and other countries. If you look at this from a global angle, right, then you can see China are negotiating BIP, right? US, Europe is negotiating TTIP, and the US is leading the negotiation for TPP in Asia Pacific region. So if all of them, are reached in the end, then they will change the global landscape for investment protection. So what I'm trying to say is, I agree with you. I appreciate that kind of argument, recognizing the effectiveness or efficacy of BIPs for international investment treaty or for foreign direct investment protection. But in reality, there's a very departing trend moving towards another direction. So in the end, we will see what will happen in reality, right? If these 3 major BIPs, TTP, TTIP, US-China BIP, are all successful in the end, they will change the landscape. Yeah.
Good morning, my name is Fernando Jaga. I'm a professor at this University Law School. My question is, between Mexico and China, to your knowledge, is there a BIP that is in place?
2008. We signed the BIP in 2008. Yes.
What is the current status of that?
We signed already.
BIP.
We are trying to, I cannot say on behalf of the Mexico government, but the Chinese government is trying to have a free trade agreement with Mexico. But that negotiation was stalled for a while because of the local arguments or dissent in Mexico. That's my understanding. We have strong willingness to move forward.
So you were talking about that China in the following years is going to make multilateral investment treaties.
Yeah.
So in the regional cooperation, well, the RCEP that and also other countries. So finally, China is going to take away all those bilateral investment treaties and only make one investment treaty for all that region. I guess that I don't know very well, but ASEAN has many developing countries, but also in this RCEP has Australia and other developed countries. So they have different conditions.
In Asia Pacific, most of these countries are developing, not developed, except Australia and New Zealand.
Yeah.
But I don't think RCEP will replace all individual VIPs. That's not the plan to abolish all the VIPs.
Thank you very much.
Good morning, my name is Alberto Sanchez. I'm studying international affairs at UNAM. My question is about, well, in the economic model of China, we can see that in the first VIP period, they tried to sign these treaties for China and now they are trying to invest in other countries. So would you recommend for Mexico like to follow the same way to attract inversion and then we become a country to invest in this Latin America?
That depends on how an individual developing country or transitional economy grows economically, right? So not every single emerging economy will move from capital importing status to capital exporting status, like Russia. So it's a very important emerging country, emerging economy, but it didn't move that direction. So there's no way to imitate China's approach for each individual developing country. It's case by case. It depends on the economic status of each country.
And I would like to know, related to the big changes in VIP generation regulation, about the approach. Like if all the VIPs have the same approach, that they protect the business from pre-establishment or post-establishment, and it is also related to in at the beginning it was post-establishment and then I don't know if China just decided to follow the other approach, pre-establishment. And the other question is regarding to the clause that you said. I don't know if it is related to the 14 clause. Like when you can choose to go to the local tribunal.
Talking to law, yes. We have that clause. Yeah.
And do you have it from the beginning?
We had that from the beginning, yes.
And what about the approach?
The approach is, in this case, it's very interesting. The tribunal, because based on the literal reading, the approach should be a vertical approach, which means you need to exhaust the first choice, then move to the second, right? You need to exhaust the local remedy, then move to the international arbitration tribunal, right? That's the so-called vertical approach in relation to the focal interlock clause. But in this tribunal, in Peru case, the tribunal took a horizontal approach, saying all these bannings can be used at the same time without exhausting the previous one. So this case will be a very interesting case, and it can be used as a precedent for future VIP incorporations.
I would like to allow not to go to the first to the local, if it's possible. I mean, do you have that kind of approach to the China?
No, Chinese approach is, put this way, Chinese approach is always trying to ask the foreign investors to use local remedies, right? But the problem is, even if you have that so-called exhaustion of the local remedy clause, that depends on how the tribunal will interpret it. Right? So it's not only about Chinese practice or Chinese way of having this VIP clause. It's really about how the tribunal will use or interpret this clause in the real case. That's my understanding.
But in the he can go directly to the arbitration without going to the local.
You mean who's he?
The investor.
Investor. Based on the literal reading, the investor needs to go to the court first to sue the Chinese government in the administrative law, under the administrative law. But the problem is, if you have this broad interpretation by the tribunal, investors are basically encouraged to go arbitration first, right?
And regarding to the establishment
Vamos a ver si puedes a convencer en
I can also.
ahorita vamos a tener un taller por si quieren integrarse. Entonces, ¿alguien más si quiere participar?
One question more. Mexican firms can improve cost. Mexican firms can improve the situation like recipients of the new and high technology enterprise policy in China with a new agreement, or it can be modified with non-agreement and investment agreement?
This China-Mexico PIT signed in 2008 has quite little relevance to high-tech investment. It's more about investment protection, like creating a dispute settlement mechanism for all investors when they have dispute with the government. So it has little relevance to high-tech investment. I'm not sure if I answered the question. Okay.
Bien, pues no sé si alguien quiere preguntar algo más, no para despedir. Doctor,